Hey guys, welcome back to the channel. So in today's video, we're going to be discussing, the state of affairs that's going on with Grant v. Rovella and how the state of Connecticut is basically stalling at every chance they can get, constantly bugging SCOTUS and begging them for more and more time. Like I always say, a right delayed is a right denied. Let's get into it. Hey, but first, before I forget, I just want to mention a few things. One, down in the description below is going to be a link to go vote in the Gundies for Micro Influencer of the Year, which the channel, I should say, had been nominated for Micro Influencer of the Year. Thus, I need your help, guys. You need to go down there and vote. All right. If you've been watching the shorts, yeah, I've been bugging you guys to vote. Some of you might not have seen them. I'm asking you for support. Go vote for the channel. Hopefully we win, and then we'll put a cool little award up or whatever. It's next month out in Vegas. More than likely, I'm not going to Vegas, so it is what it is, but I would really appreciate all your support and your help with that. Also, normally we do a Saturday night live, but this Saturday, I'm teaching all day, and then the Army-Navy game is on in the afternoon. Thus, I will be busy watching the Army-Navy game with Mrs. Guru. It is literally the only football game I watch ever. Not big into football at all. Going to the Army-Navy game has always been on our bucket list, and luckily 2 years ago, we were able to go see the game in Boston, which was an absolute blast, and it definitely felt great to be able to check that off the bucket list. So Saturday night, I'll be watching the game. So instead of doing a Saturday night live, we're going to do a Friday night live. So 7 to 8 p.m. this Friday, which will be the 12th. December 12th, 7 to 8, we're going to be doing our live. And we'll be discussing all the things that's been going on. Granted, it's the time of year where the news is kind of dead, especially when it comes to the Second Amendment. But we're going to do our best. And I'll talk to you guys about what happened over the weekend, which is a little nutty. It was quite an adventure. So we'll discuss that. I'm going to save it for that. Plus, over my shoulder, you can see Clay the Claymore.
Tired of the same old tactical gear? Want something soft, squishy, and strategically adorable? Introducing Clay, the Claymore plushie. It may look like a deadly anti-personnel mine, but don't worry, this one's armed with comfort. Made with ultra-soft, stress-relieving materials, you can squeeze it, squish it. Go ahead, smooch that adorable face. It won't explode, but your heart might.
Bang.
And why is Clay sitting there? Because me personally, I think Clay is pretty cool. But for you guys, Clay is going to be our December 20th giveaway during the live. So tune in for that and just comment, participate, make me know that you're there and you're alive, and we'll throw you in the mix and we'll give Clay away and we'll send you some stickers and patches and all that good stuff. And of course, before I forget, like I always say, best way to support the channel is down in the description below will be a link to the merch store. You can always become a member here on YouTube or on Patreon, locals, things like that. But you know what's free? Just liking this video and sharing it with everybody you know. And if you haven't already subscribed to the channel, please take a moment, subscribe to the channel, and toggle that notification bell, ensuring that you always get updated anytime I put up a new video or I do one of the lives. All right, let's get into it. So what are we talking about? We're talking about Grant v. Rovella. You guys also may know it as Grant v. Lamont. It is one of the lawsuits dealing with Connecticut's AR-15s ban by name and features, and it's also what they deemed as a high-capacity mag ban, which is standard capacity magazine, technically. So this lawsuit is before the Supreme Court looking for cert, which means the Supreme Court will pick it up and hear the case. Well, it was due to be heard, the arguments from SAF and CCDL and their lawyers and Connecticut were supposed to argue to see if SCOTUS would pick up this case or not last week. Connecticut, I guess, isn't ready, and they asked for an extension, and they gave it to them till like this week. And then they asked for another extension. Now, I have seen, and if you follow me on any of the social media platforms like Facebook at Gun Guru Actual, I put up a post saying, hey, December 18th is a hard deadline according to the SCOTUS. But then the CCDL came out yesterday and said that Connecticut was granted a 30-day extension. So now it's all the way out to January 12th. So next year. That being said, why does this keep happening? I really don't have an answer for you. There is really nothing that I can find online that explains any of this from either the state's point of view, and we all know the CCDL is pretty much mum's the word on everything, and SAF isn't sharing anything either, and I get it. I wish they were both better at communicating what's going on, but they're not, and it is something we just have to deal with. And that's why I'm here, trying to figure it out for you and explain it to you. So why does the state of Connecticut keep delaying the inevitable? Well, because I think they're a bunch of cowards. Personally, I think the state of Connecticut is taking a look at all the gun cases throughout the country and seeing how they're falling one by one in favor of the 2A community. SCOTUS has come out and pretty much said that the state of Connecticut is wrong. And they've said that about a lot of the circuit courts that have been basically aborting Bruen or not following it the way it was written or trying to reinterpret it in another way, where Bruen did say specifically that, yes, a state or the federal government could ban a gun if it was deemed dangerous and unusual. Connecticut and the Second Circuit decided they could ban guns if it's dangerous or unusual. All guns are dangerous. Nobody's going to say they're not. And that's what Connecticut's choosing to say, nope, see, it's constitutional because we deem these guns dangerous. All guns are dangerous, especially in the wrong hands or untrained hands. That being said, the reason the dangerous and unusual has to meet together is because this way they can't just ban stuff willy-nilly. Now, we all know the AR-15 is the most popular rifle in the country. And standard capacity magazines for those rifles are 30 rounds. Standard capacity magazines for a Glock 17 is 17 rounds. The standard capacity for a P320, I'm just looking at one of our magazines here that's capped at 10, looks to be maybe 15 to 17. Could be wrong. Could be up to 18. I'm not sure. Ours are capped at 10. And since all my magazines are state compliant, really couldn't tell you. I have no idea why all of this is going on. I know that the arguments that CCL and SAF have are rock solid. It is some of the best arguments I've ever seen in any of these cases dealing with AR-15s. And instead of SCOTUS just continually kicking it back down to lower court, saying, nah, you got it wrong, here, try again, I think the SCOTUS needs to just pick it up and finally hear the damn case and give us the final word. Basically, states cannot ban these types of guns just because they don't like them. It's that simple. So no more delays. The state needs to stop. I mean, if their argument was so rock solid and they were so sure that they were right and they would prevail, pretty sure their argument would have been in right away. But the fact that they keep delaying and trying to push it off and begging for more time, they might think that their case is pretty shaky and it might fall apart in front of the justices. Let's hope so. So I know you might be asking yourself, hey, Todd, why are you making this video? You really have no information. Don't mind me, I'm drinking my Jack Daniel's coffee. It's absolutely delicious. Well, that's simple. There is no information. You're right, there isn't. But I'm letting you guys know that this is what's going on. These are the games that the state of Connecticut plays. It's not a hurry up and wait. It's more like a let's stall as long as we can, so maybe the other side will lose some sort of momentum. honestly, I think it's just fomenting the people, and they're just getting more and more pissed. I know myself, personally, get more and more pissed every day, not just at the state of Connecticut and their idiotic views of the Second Amendment, but I'm getting pissed with the Supreme Court for not taking one of these cases long before. There's a trend. You pass Bruen, you pass all these other pro 2A decisions, and then the circuit courts and states just simply ignore them. And instead of laying down the law and putting your foot down, drawing that line in the sand and say, okay, enough is enough, SCOTUS just kind of keeps ping-ponging it back. Like, oh, well, they screwed it up. Throw it back to the lower court. Lower court's like, no, we did nothing wrong. Goes back up to the Supreme Court. They're like, no, still wrong. Try it again. Stop doing that. Just pick up the case and say, okay, obviously the lower courts are partisan and can't figure it out. The law that we passed, or the way we interpret it, Bruen, says these things: text, history, tradition. And look at it. They are the Supreme Court of the land. Once they make a decision, that is it. Now, sometimes those decisions are wrong, and they do get overturned. It's not like the end-all, be-all. We saw that with Roe v. Wade. Roe v. Wade was founded, and they said, yes, you can do all these things. And even Ruth Bader Ginsburg herself disliked the Roe v. Wade findings because she thought they were pretty damn flimsy and could be turned around on its end at any point, which it was a couple of years ago back in Trump's first term. So like I was saying, I have been digging for any information on this case outside of the briefs that we have originally when they went up for cert, which is like SAF's and CCL's argument. We're waiting on the state, obviously. Looked around, there was nothing. Just crickets, except for the one Facebook post from the CCDL just saying, it's been delayed. The state of Connecticut has been granted a 30-day stay. So, listen, I'll, keep my eyes on the internet and on all these cases, see what pops up. But for right now, honestly, it's a very, very slow news cycle just because Christmas is coming up and not much is happening. And it is what it is. I know all of you are probably getting pretty antsy too. So it's a hurry up and wait game at this point. And hopefully it'll be great news when they pick it up, whether they pick up the Grant v. Rovella or the, I want to make sure I get the other case right. The other case is Flanagan v. Lamont, which is another AR case and magazine ban case, but this one's out of South Carolina, but it too is right before the Supreme Court. I haven't seen any updates on that from anybody, and the CCDL really doesn't care about it because they're not involved with that particular case. And this case involves not only Flanagan as one of the petitioners, but it also is from American Gun Owners Foundation, Gun Owners of America, Gun Owners of California, Coalition of New Jersey Firearm Owners, Tennessee Firearms Association. That's a great group, by the way. I am a member of that. The Tennessee Firearms Foundation, Virginia Citizens Defense League, Virginia Citizens Defense Foundation, America's Future, U.S. Constitutional Rights Legal Defense Fund, and Conservative Legal Defense and Education Fund in support of petitioners. So they're all involved, while Grant v. Rovella is just the CCDL and the Second Amendment Foundation, which is a great group. So, the CCDL is not giving us much of an update on Flanagan v. Lamont. But that, too, is before the Supreme Court, and a few other gun bills, or I should say, a few other unconstitutional gun laws are there, too. So we'll see which ones get picked up, and even if Connecticut were to submit their brief in a timely manner, it's not like we know it gets picked up for cert overnight. It does take time. So sometime next year, I guess. I mean, it is what it is. So there you go, guys. It's a video about a case that everybody's interested, that we have no information on, that the state of Connecticut keeps stalling on. So basically, it feels like we're running in circles. That's all I have for you guys in this video. Don't forget, guys, down in the description below is going to be a link to go vote for the Gundies, voting for me, Gun Guru, the micro-influencer of the year. Now, there's plenty of other categories where you can go through and vote for your favorite YouTubers or GunTubers. There are a few I go through and I vote for, like Unsubscribed Podcast, and a few other YouTubers that I know, and they're friends of mine, so I vote for them. But if they're in my category, it sucks for them because I'm voting for myself. Obviously, pick up some merch, and I will see all of you guys Friday night on our live. Otherwise, I'll talk to you later in the next video.